So in addition to insurance, which we've talked about, another great tool for artists to minimize their exposure to risk is through contracting. And in a contract, for example, if you are a photographer that goes and shoots an event, say a wedding, that's really precious to somebody, a really smart thing to do would put a clause in that contract that says, and if, worst case scenario, the camera breaks, I lose all of these images, you agree that the maximum you could hold me responsible for is the amount of the contract, i.e., I'll return your funds, but you can't then take me to court for the emotional distress I've caused you because I lost all of your precious photos. And that's an absolutely appropriate and reasonable thing to have in a contract. And that's just the kind of thing that you can do on the front end to protect against that, once or twice in a lifetime thing that may happen that could derail an entire career. If you think about if you did have to get taken to court by a potential client or a commissioner and over a suit like that, that not only would tie up your time, energy, and money while defending yourself against that, which takes away from creating your artwork, but also may make it much more difficult for you to continue working in the future. So that's just an example in a photography, but I think you could see how it could apply to many different genres of artwork. One of the common things I hear from artists when we sit down and talk with them and identify some of those risks, and we suggest using a contract, for example, for a commission or when working with a gallery or in collaborating with another artist, and they say, well, wait a minute, these are my friends. If I just march in with a contract, isn't that going to put them off? Doesn't it feel adversarial? Isn't it a bad way to start a relationship? Or I might start on the wrong foot, or they might not want to work with me at all. And our strong feeling and what we've seen from much evidence over the years is that, first of all, good contracts maintain good friendships. The quickest way to destroy a friendship is to not have a true understanding of the working relationship that you're entering into with another person, and a dispute's going to come out of that 9 times out of 10. So if you do have it laid out clearly, plain language, doesn't have to be complicated or overly involved. It can just be a few pages and just your expression of plain language of what your understanding is of how you two will work together. That's a great way to start off on a very professional foot. I think you'll find that the other party will respect you, and that they'll see that you're business-minded, that you are professional, that you're ready to work with them, and it'll build trust as opposed to fostering discord. And that's what we see time and time again. Artists say, okay, for the first time I brought that agreement into that gallery that's never agreed to have an agreement with me before, and they were impressed and they were willing to work with it. And another advantage of having your own agreement that you're comfortable with, that inside and out, that you can bring to another party, is that that's often going to be the agreement. So that's going to be most protective of you. Whereas if a gallery is handing you their agreement, that's going to be most protective of them. So being proactive and bringing a commission agreement that is artist friendly, or a gallery agreement that's artist friendly, that you're protected and you can feel good about that document, and you can explain it to the other party too. And most often in a business dealing, people want it to be a win-win. They want it to be a true collaboration, and the best way to ensure that is through having it in writing. And so in the event that you are offered a contract, that's always one of those situations where we say, at a minimum, read through it yourself carefully. Think about what sections you have questions about, what sections you would like to change, frankly, and keep in mind that no contract is non-negotiable. There may be aspects of it if you're contracting with the government, for example, or some other larger party that has more bargaining power than you. Sure, they're in a better position, and there may be some provisions that aren't negotiable, but I think you'll always find that there are some places that there is some room to bring it closer to what would protect your interest as well. And most contracts are drafted under the assumption that the other party will be represented and will bring back some negotiated points, and that it will end up somewhere in the middle. So if you take a contract that's drafted one-sided and just sign off on it, you've missed an opportunity to bring it back to the center and something that would be more fair for both parties. And that's something I think often artists don't realize, is they assume, well, if this is the contract the gallery gave me, this must be fair and complete, and there's probably no room for me to ask questions about it. They might not want to work with me if I ask questions about it. But actually it's the opposite. The assumption would be that then that contract would be reviewed by you and your attorney if you can afford one or find one through the Volunteer Lawyers for the Arts, and then that you would bring back a couple points and that you would meet in the middle. And that's the presumption with all contracts, really. So keep that in mind too. It's never a take it or leave it deal.